Hello everyone, welcome to Legal Darshan. In our first two videos, we covered the syllabus, the eligibility conditions, the criteria, and how to crack DULLB entrance exam. So today we are going to start with jurisprudence and legal theory. Jurisprudence is an essential element of law. It is a subject which defines what is law, how to read law, where did law come from, what are the basic underlying principles that promoted the evolution of law. So, in this series, we will be talking about origin of law. How did law evolve? From where did law come into existence? The major legal systems of the world. There are three major legal systems. We will be talking about them in our video further. The Indian legal system. Since we are living in India, the jurisprudence of Indian context is very important for us to know. So, Indian legal system. Sources of law. From where does law comes from, like what was the origin, as we will be studying it in our first topic. So sources of law, there are primarily three sources of law: the customs, the precedents, and the legislature is which enact the laws or make the laws. Then we come up to various schools. Various schools are natural schools, sociological school, historical school, positive school, and so on. We will be talking about 5 schools of jurisprudence, how the jurists to these schools contributed in with their legal theories in law and rights and duties. So, law and jurisprudence. I would like to tell all my budding lawyer friends that we all make a tiny mistake which is not accepted in this field. Like we do not take how to write LLB properly. So first of all, when we talk about law, the degree is LL.B. That is legum baccalaureus, meaning bachelor's in legal studies. So how to write LLB? Often we make a lot of mistakes. The right way to write it is LL.B. We either forget to put dots either before B or after B, or we write a letter in small, which is not correct. So the right form is LL.B. One thing I would like to tell you, that there will be a lot of maxims, a lot of terminologies coming in our studies, in our course, and they will be in Latin. So the language of legal studies is primarily Latin. Jurisprudence, as the word breaks down into two small words, juris and prudence. Juris means law, prudence means a sense, wisdom, knowledge of a thing. So wisdom or knowledge of law means jurisprudence. So one thing you should take into account is wherever the words like juris, lex, and just comes into your view, it means the context is law. It is talking about law or legal studies. So moving on, legal systems of the world will be our first topic, in comprising of origin of law, how did law evolve, and what is law, what is the definition to law, what is a legal system, and major legal systems of the world: Romano-Germanic family, common law family of socialist, customs followed by different countries and different communities we will be talking about, and Indian legal system, which is a set of features from all the major systems across the world. So beginning with origin, the very first existence of law, when there were no written account of any legal system, when there were no legal system found, was in customs. The first account is to be found in the customs and usages, followed by the agricultural community. Suppose a rule was laid down, everyone will be following that rule. That rule is not in against to public policy. It kept on being practiced for years and years in a continuous manner. A generation after generation started practicing them. They became law because they were not in opposed to public policy. They became law. Originally, it was in agricultural sphere. Gradually, it extended to economic, social, and political roots. So, what is a law and how it is different from rules? When we were all in school, in our primaries, we were morally given some rules to follow. Wake up at 6 a.m., do proper brush, wash yourself, but and pray and come to school in proper uniform. Suppose if a student doesn't follow the rule, he wakes up at 6 a.m. He doesn't wake up at 6 a.m. and wakes up at 7 a.m. He's not making any wrong to any other person. This is not a crime. This is not a heinous crime, or he is not doing this to make someone wrong or make harm to someone. This is a moral value. So this is a rule. And similarly, on the same side, if a pedestrian is walking by and a motorcyclist breaks the traffic signal, hits the pedestrian, he is making a wrong to pedestrian. Thus, the following of traffic light is a law, because it is ensuring the safety of pedestrian, the motorcyclist, and any other individual traveling by the road. So there are certain rules that only need to be followed to enhance our moral values, and there are certain rules that are enforceable by our system to protect the individuality, the justice, the fair play, the equity in our society. So those rules and regulations which are enforced on the people are called law. Enforcement of law. How is law enforced? A whole system comes together to enforce the law. There are lawmaking bodies, there are law enactment bodies who enact the laws, and there are laws governing bodies which governs that the law is being followed properly. And of course, this system cannot be completed without the part who is following the law. If there is no one following the law, then the need of three other categories is not required. So, law following or law abiding parties. Now, what is a legal system? This whole system which makes sure that law is being followed is known as a legal system. Parts of legal system are sovereign, legislature, people, we the sovereign in India, a judiciary to interpret the law, lawyers and legal personals, executive enforcing the judgments and decisions made, and sources from where are these principles coming from. All these constitutes a legal system. Now we will come up to our topic, major legal systems across the world. There are three major legal systems. Romano-Germanic family, known to be oldest. Then came the common law family, and the third one is family of socialists. So moving on to Romano-Germanic family, it originated in Europe, and it was a joint effort of the jurists and legal scholars of Greeks and Germanic universities. It was officially known to be the first legal system across the world. They developed a principle, or not developed, they worked on the principle of jus civile. Now, jus civile here is a Latin word. Jus means law, civil means of the people. Law of the people was their basic legal principle behind their theory. So the matter between the two people was decided between two people only, and there were no need of courts and administration. So when we talk about two individual people, there was no court, there was no proper settlement team like a jury, a judge. They didn't mention the need of it. They just mentioned that the matter between two people should be settled between two people. It may vary from people to people how they solve their matters. So this was more abstract. Then their rules were conceived from morality and justice. Natural school has a big role in shaping Romano-Germanic family. There was a separation layer between the law enacting bodies and law enforcing bodies, like in executive function and the legislature function. So this family was basically protecting the individual relationships of citizen rather than working on public law. Public law was a lower extreme in this Romano-Germanic family. It regulated private law between individuals more. The law demanded to be codified, and as I told you, it evolved during the evolution of natural law in the legal context. Next, we come up to common law family, where the civilian law was being followed in Europe. The jurists or legal scholars in England derived common law. They formed their own theory of legal system, and this family was called common law family, where judges played an important role. The judges resolved disputes, and then an idea of common law for all the people was brought forward. The law, this kind of law, this family of law was the creation of judges and jurists and legal personnel in England. It didn't demand codification. It strongly agreed to solve the problem rather than settling it. The rules of the common law were formulated on the basis of precedent judgments, like the judges who were deciding the matters earlier before the common law, they made their judgments the precedents of their law that would be followed for people as a whole in England. It gave a general rule of conduct, whereas when we talk about Romano-Germanic family, it was missing a general rule of conduct since the matter was to be settled between two parties on their own. There was no general conduct. The people to the parties could have settled the matter on their own. So the general conduct lacked there. It came out more as a public law, and judges had a premier role in common law family. It basically linked up the individuals to the system and government. So it majorly came out as a public law rather than private law among individuals. Last is family of socialists. It is our third family. It broadly originated in USSR and prevailed since Revolution 1917. They derived a major portion of their theories from civil law, Romano-Germanic family. Therefore, it can be said as an inherited family of Romano-Germanic family. It is based on the civil law system, and major modification and additions are taken from Marxist-Leninist ideology. So, it created a civil code. The courts interpreted a civil code, approached the legal reasoning, and solved the matter. So the rules that were interpreted were based on the conduct of the society in a civil form, in a code form, needed to be followed by everyone. So while civil law systems have traditionally put great pains in defining the notion of private property, how it may be acquired, transferred or lost, socialist law system has provided the property to be owned by state or by cooperatives and having special codes and laws for state enterprises. So broadly we can say that this was a modified branch of Romano-Germanic family that found its existence in USSR post-revolution in 1917. So what you are going to do is to deduce the differences and similarities between these three systems and drop us your feedback at legaldarshana@gmail.com. You can also drop your feedbacks, your comments in the comment box below. Please let us know if you find it's appreciable, or if you want us to add something or change something. All your suggestions are welcomed for this series. This is a step forward to make people aware about jurisprudence. It is a project for students' welfare. So what we are going to study in our next lecture is Indian legal system, different schools of jurisprudence, sources of law, rights and duties, and smaller sections which are constituting these subparts of these sections. We will be covering them in our future presentations. For any queries, suggestions, information, you can feel free to contact us at legaldarshana@gmail.com.